In the Georgia trials of Donald Trump news, one of Donald Trump's alleged co-conspirators, Mark Meadows, has sought to remove the case against him from a Georgia state court into federal court under operative federal law. So this is a rarely used procedure that is available. Whether it's available in his particular case, I couldn't speak to, although based on his pleading, it seems like he has a pretty good superficial case. Long story short, if you are being tried for something that relates to your official job capacity while you were in office, then even though it's criminal in nature, even though it's state criminal in nature, it will be tried in a federal court. So it's still a state case. It's just moved to federal court, removed to federal court. So you get a federal judge sitting over a state case, because the federal law provides for that. So you have this option of taking it out of the state court and removing it to federal court, or at least that's what we're trying to do. So let's learn a little bit more about what's going on in this. Let's get started with this. Mark Meadows has filed a motion in the U.S. District Court for the Northern District of Georgia, arguing that the charges, which are now proffered by the state level authority in the form of Fulton County District Attorney, that it covers conduct that occurred while he was a federal official. So therefore, it should be tried in a federal court, notwithstanding the fact that it's state level charges. In the motion, Meadows' attorney cites the federal law, which is known as a removal statute, which generally allows for any officer of the United States who's facing criminal prosecution in state court to move those proceedings to federal court if the case relates to actions that were part of the individual's duties as a federal official. So the idea that, if you're a federal official performing your official state federal duties, right, and some state wants to charge you with state level conduct, well, there might be a problem, because a state might, at least theoretically, make something illegal, which the federal government might require as part of your job duties. So you could imagine some state somewhere enacting some kind of law that would criminalize something that would be fully legal as far as the federal government is concerned. And the idea would be the state level officials want to prevent the federal level officials from doing their job. All right? We're not going to allow you to enact your law here or perform your actions here. And you've actually seen this, incidentally, with states trying to do this, for example, to make it illegal, for example, for federal law enforcement officers to enforce federal law. It's like, you can't do that. And if you do that, we're going to hold you criminally responsible in our state because you're not allowed to do that. Well, the federal government has a thought about that too, under the supremacy clause. So, unsurprisingly, a state cannot make illegal what the federal government explicitly makes legal because of the whole supremacy clause things. It's like, we're not going to allow you to effectively nullify federal action through a state level proceeding. So therefore, it can be tried by a federal judge who will be in a position to decide such things as, hey, wait a second, maybe this state level proceeding, which is superficially a criminal proceeding, is actually a proceeding designed to thwart a federal officer in the exercise of their actual official duties. So one of the reasons that you do that is because of that, exactly that reason. So he's like, okay, let the federal government decide whether or not my actions were within the scope of my job duties. If they're within the scope of my job duties, they can't be illegal, no matter what Georgia thinks, because if Georgia could think something different, then Georgia could effectively illegalize a federal officer's conduct, and obviously that'd be really dumb. So that's basically what's going on in all that. According to Meadows' attorneys, Mr. Meadows is entitled to remove this action to the federal court because the charges against him plausibly give rise to federal defense based on his role at relevant times as White House Chief of Staff to the president. So because I was doing an official job for the federal government in my official capacity, Georgia can't make my official actions illegal, because Georgia can't make federal government actions illegal, because that'd be really dumb. And so they're trying to argue that what he's trying to do was within his job duties. Now, was it within his job duties? I don't know. But that's what he's trying to argue, right? And it should be a federal court who decides, not the state court who decides, because the state court would obviously decide, well, hey, of course these aren't within his federal duties. What a stupid argument. So only the federal courts should be able to analyze that question. The filing requesting that this be transferred to the federal court comes one day after the Fulton County grand jury signed off on a sweeping criminal indictment, which incidentally was docketed against Donald Trump before they signed off on it, which was a neat trick, right? As we all saw, right? It was docketed saying, hey, Donald Trump has been charged with a whole bunch of things. That's really interesting because the grand jury hadn't finished voting yet. So, I mean, there's that. So, yeah, it's like maybe something is wrong in the state of Denmark. Meadows, who is a former North Carolina congressman who served as Trump's chief of staff in 2020, was indicted on 2 charges: violation of Georgia's Racketeering Act, which everyone's been charged with because why not do a RICO, and solicitation of violation of oath by a public official or a public officer. And the idea is like, I was trying to get you to violate your oath, which, okay. Among other things, the indictment cited Meadows' calls and emails to state officials in Georgia and other battleground states as Trump and his associates sought to undermine what we now believe to be legitimate election results. Although at the time, maybe that belief was less assured because we have to remember things in different time frames. It also cites a surprise December 2020 visit Meadows made to Atlanta area facility where state election workers were auditing ballots and his role in arranging a Trump phone call with his Georgia Secretary of State, which, as chief of staff, probably would be something that he might do. The president wants to talk to somebody, someone else is probably going to arrange the phone call. So the idea that he was helping to coordinate the phone call, yeah, that would be something that you would expect. In the call, Trump urged the Secretary of State to find the vote necessary, which apparently was violation of oath of office or something. Which, okay, maybe, but the whole thing is a little bit weird. In the filings, it has been argued that nothing Mr. Meadows is alleged to have done is criminal per se, which is something I noted for many of the supposed acts that were committed in furtherance of the conspiracy. I'm like, a lot of these are really legal, and not a lot of them seem to be illegal. So you're putting sort of the cart before the horse on that one. Why are you alleging all these legal things as support? Where are the illegal things? It was a very strangely drafted things. And he says none of them are criminal per se, which, arranging a telephone call with the Georgia Secretary of State is not criminal in and of itself. So, right, it's not criminal per se. He's also apparently been accused of arranging Oval Office meetings, which, would be part of his role as chief of staff, contacting state officials on the president's behalf, same, visiting a state government building, same, and setting up phone calls. One would expect the chief of staff to do these things. Yeah. So these actions seem to be within his role as the chief of staff. So therefore, whether or not he was doing something criminal is not necessarily for Georgia as a judge. So I think he has a good superficial claim. This should be transferred to the federal court. Meadows' petition to move the case to federal court was widely expected, with Trump and former Justice Department officials expected to pursue similar motions. Yeah, so probably. I mean, a lot of these things happened while Trump was president. So, yeah. In fact, I'm not sure any of them. Well, no, they said the conspiracy extended beyond, but we'll see. If approved, it would allow the case to be heard before a potentially friendlier jury pool made up of residents summoned from a greater part of the state, which will be more conservative than the heavily Democratic county, because federal districts are bigger than counties. So it will allow the jury pool to be someone from a wider area, also someone who's not a state level official, to judge the whole thing. And so maybe you'll get someone who's a little bit more friendly. And also, of course, in the appeals would necessarily be heard within the federal system. So there's all that. So it puts you on a collision course with the U.S. Supreme Court right away. Trump previously tried a similar legal maneuver in New York, where he's facing charges in business record. A federal judge there rejected the effort and kept the matter in state court, saying the charges there did not involve the duties as president, which, fair enough, because those duties involved Trump's business concerns, which did not involve him as president. So without looking in the details, that is superficially a plausible distinction. So Trump said, okay, the state level charges relate to my duties. They're like, no, it doesn't. Also, because because the timing of various things were different. So that makes sense, but perhaps a different decision here because a lot of these things happened while Trump was president. So I think the odds of this being removed are better. The move in Georgia came as Atlanta awaited word of who among the 19 people will be the first to surrender and post bond in the closely watched case. The move in Georgia came as Atlanta awaited word of who among 19 people charged in Monday's indictment would be first to surrender and post bond in the closely watched case. Willis gave those charged a deadline of noon on August the 25th to appear in Atlanta, where they'll be fingerprint and processed and booked and have a booking photo taken, which in Trump's case, I would imagine, will be one of the most circulated photos on the face of the earth and will soon appear on many, many t-shirts, both by Republicans and Democrats, who will be putting the same photo on t-shirts for very different reasons. An initial appearance before the judge could then come or might come in subsequent weeks. So all that good stuff. Thus, that brings us to the end of the story for the moment about the whole Trump indictment and efforts by Mark Meadows and presumably others to follow to take this thing to federal court because it relates to things that occurred during their work and capacity as various federal officials. Mark Meadows argues that he's alleged to have arranged phone calls between the president and the Secretary of State of Georgia, for example. And that's something that he would do within the scope of his employment as the White House Chief of Staff, which makes complete logical sense. And so he's like, it seems like Georgia might be trying to step on a official federal function rather than pursuing legitimate charges, because Georgia obviously can't criminalize something the federal government makes legal. And so he was pursuing his job role. So he wants this taken to federal court. And I think he has a pretty good argument. It should be taken to federal court. And also many of his other people charged, including Donald Trump himself, might want to pursue this. Donald Trump tried this in North New York to less success, but the rationale for taking it to federal court was much weaker in the New York case and much stronger here. So this may get transferred to a federal court, and then we're off to the races on the whole thing, and that should be interesting. And at least for a moment, that brings us end of discussion of this story.